Hi, my name is Joseph Chambers III, and I'm here to talk about special education laws, the past and the present. So let's start with the past and take a stroll down memory lane to see the steps that were taken to get to where we are now. I find it quite astonishing at the fact that there are so many special education resources and programs in effect now that weren't in effect back in 1970 due to what was thought of by the court system and the public eye. In 1933, parents of special needs children were advocating for them and fought very hard to get them into the public school system. However, it was falling on deaf ears as the public and the courts felt that there is no need for a kid with special needs or disabilities to be in a public school setting. In 1950s, parents were starting to make headway by getting litigation passed so that teachers could get formal training for children with special needs and disabilities. In 1960, various laws were passed permitting funding for special education programs and services. In 1973, the Rehabilitation Act was established, which gave students with special needs civil rights and a place in a public school classroom. In 1973, Maryland passed law requiring education of children from birth to 21 with educational disabilities and special needs. For a side note, Maryland is where I'm from currently. In 1975, Education for All Handicapped Children Act, which enforced children with special needs to get a free public school education. In 1997, the EHA underwent several revisions and became known as the Individual with Disabilities Education Act, or otherwise known as the IDEA. The IDEA emphasized the use of individual education plans or IEPs for all special education students. Now, in the present, the states and institutions give 91% funding to schools for children with special needs. So, as you see, from 1933 all the way up to 1997 to now, there have been various steps taken to help special education get funding for resources and programs in the public school, not only just in Maryland, but also across the country. Now let's go over court decisions that ruled in favor of children with special needs. In 1954, Brown versus the Board of Education, the Supreme Court ruled that segregated schools are unlawful, not just segregation between black and white, but segregation from special needs kids and kids with disabilities. In 1985, Burlington School Committee versus Massachusetts Board of Education, Supreme Court ruled that parents were to be given back money spent for special education because, as you heard prior to in the past, parents were paying to get special education services, but through acts being passed, parents were getting it for free, so they were getting their money refunded because of that Supreme Court decision. In 2007, Jacob Winkleman versus Panama City School District, Supreme Court ruled that parents can request claims into the IDEA. It used to be that parents had to go through a very lengthy process, but now they are able to put formal claims into the IDEA by themselves. Fry versus Napoleon Community School District ruled that a child service dog was able to be allowed in the school. Prior to, for kids with disabilities and special needs, they could not have a seeing eye dog or any hearing aid or such, but now it is allowed in school due to this court decision. Christopher Rausch versus Dr. Haritha Fountain, the court ruled that in Montgomery County schools, they had failed to adhere to the IDEA and were asked to make amendments to it and make sure that it would fit the child's needs. On June 4, 2001, Chad Tabor versus Baltimore City Public Schools ruled that there would be an extension given to amend the unjust education laws that were in Baltimore City schools due to the fact that the children getting a lack of education. Well, that is my presentation on special education laws. I hope you enjoyed it. Until next time.